before the board goes into deliberations or opens it up to any public comment, I wanted to just highlight a couple things to help clarify and keep everybody on the same page, because I know this is a very confusing application. First, I did have some ex parte communications with the chairman and with the applicant's attorney just to go over procedure, which order we take the decisions in. Today you will be making decisions on, you're required to make considerations and findings on the zoning, the special exception, and the variance. And for the record, the rezoning is supported by the staff and by the applicant. There's, as I stated before, there's no testimony as yet has been put in against that rezoning, so we're basically in agreement on those findings. There is a question in the special exception. Primarily, it seems to be about the 500-foot separation in extraordinary circumstances. The variance is only really applicable to this consideration if you find that that 500-foot separation is a hard bar against them moving forward. I do recommend that you make recommendations on both the special exception and the variance, because this could be insightful to the city council when they consider the same applications. So to the extent you may find that the special exception acts is a permissive review versus a hard 500, I'd still recommend you still make a decision on the variance so that the city council has the benefit of your expertise. Now, as far as you know who the applicant is. I'm representing the board. I'm here to help assist the board in making sure that this is quasi-judicial proceedings are followed and it's a fair and impartial hearing. Mr. Spain is here representing staff and advocating for the staff's perspective, just so that everyone's clear on what everyone's role is. I just wanted to kind of get that out there before we got into deliberations.
So on the break, I asked the counsel for the applicant what their preference would be in taking up the three questions. My concern was that if, for some reason, this board decided not to grant the special exception and/or the variance, would they still want the rezoning? And the council advised me that they would like us to take up the rezoning first, which would be the normal course of business, but I wanted to give them an opportunity to say, well, maybe we don't want the rezoning if you... So that's the order in which we'll proceed. The rezoning first.
Right.
And as between staff and the applicant on that question, there does not seem to be any disagreement. Whether or not that bars us from disagreeing with staff or...
Absolutely. I mean, both sides have burdens to prove. You are the ultimate fact finder.
But they both agree.
They do agree, and I
So,
don't see any public yet, but once you open up the public,
right,
maybe someone will run in
okay.
with a whole lot of facts.
So that question,
Same
So-
people that came to the
right, exactly.
neighborhood.
Okay, so before we get to that, this is a period for public comment. Is there any public comment?
There being no public.
There being no public comment, is there anything further from the applicant or the community development?
I would just note that the fact that there's no one here and no one came to our community meeting, you know how contentious things can be when there's a genuine concern about those. I think that to some degree speaks volumes.
Thank you. Okay, so the first question that comes before us is whether or not to approve the rezoning requested by the applicant.
Right.
What is your wish?
I make a motion that we accept that motion to rezone.
There's a second.
Yes.
Is there any discussion on that?
I hope I'm not out of order here, but I think we should leave the zoning in place and just deal with the special exception. So I am opposed to changing the zoning at this time. Uh,
My concern with doing that is that I think we, as a quasi-judicial board, have to have a reasonable basis for refusing what has been both recommended by the staff and by the applicant. And so that I think that unless we can provide some reasonable explanation for why we don't want to do that, that we would be in a problematic situation to do so.
And I understand what you're saying, but I don't know that we, as a board, completely understand what the council's
Well, that's,
mindset was at the time that they made these changes. And for that reason,
yeah. Go ahead.
I would not change the,
If I may, just to clarify, with the rezoning, I put the approval criteria for the rezoning only, not the 500-foot rule, not the fast food use, just the rezoning criteria up on the screen there. And those are the criteria in which staff is to evaluate the request, and the board is to take those criteria into consideration. If you do choose to deny the rezone, you can, but I think what we were getting at is that council would want a reason why, based on that criteria, where the concern lies based on that specific criteria.
And I did ask the question that was concerning me was if we vote in favor of the zoning change, that doesn't put any sense that we are supporting a fast food restaurant, because that's a new thing that's on the criteria of this new thing. And I didn't want that to be read, that was our approval of that, because if they wish to come forward, even under the CC classification, they have to come forward under this overlay process, so that this would not be read as any approval from the zoning board of what they're attempting to deal in the variance. But I don't see what basis we could use to say no, and that would make me uncomfortable anyway.
Mr. Worcester?
Mike, I have a question about that use. The first one, if it's approved, you get compliance with the comp plan and other applicable codes and regulations. Now, would that mean that they would have to bring the site up to current standards?
Yes, but it depends on the situation. So going back to your stormwater question.
Yes.
If there was a need for that to be brought up to compliance, say because it's a vacant site or an undeveloped site or a site in which they're changing impervious, and the code specifies when you make those changes, you have to revise your stormwater permit, then absolutely.
Okay. Okay, so that would still be valid unless they change the imperviousness of anything on the site?
Correct.
I'll just add in, while the presentation continued, I went and looked up the rules just to be sure, in case
Thank
it
you.
influences your decision. But under, this would be a water management district, environmental resource permit. The site would have been permitted, provided the changes either lessen the impacts to stormwater or do not increase the impacts, then it is exempt from additional permitting or modification. So it effectively is a grandfather permit to the extent they're not changing impacts to water resources.
Can I ask a question about that, though? If you were going from a bank to a fast food process, it would seem to me there would be a lot more water involved in,
That's
it's stormwater.
Stormwater, not consumption of
Okay,
water.
I'm
yeah.
sorry. Get all these different water things straight. Thank you.
Sorry.
Any further questions or comments from the zoning board? Hearing none, we'll call the question. The question being whether or not to approve the rezoning. A vote yes approves the rezoning. A vote no denies the rezoning. Please call the roll.
Bobbin Serpy,
Yes.
Barbara Craig,
Yes.
Russ Wynn,
Yes.
Sherman Carlender,
Yes.
Richard Donnelly,
Yes.
Roger Brunswick,
no.
James Worcester.
No.
The vote is 5-2, and the zoning board has approved the rezoning. The next question, Mr. Rooney, The second is the second question the special exception or the variance?
Variance.
The
Well, we're-
variance, right?
The staff's recommendation is that it is the variance because without the,
Right.
it moots the
And I
other
know
issue.
that the applicant agrees with that.
Yes.
So, do I hear a motion as to whether or not to approve the variance requested?
And I'll put the variance criteria up on the board for you one more time.
I move that we disapprove.
There's a motion to disapprove. Is there a second?
Second.
There's a second. I'm waiting for them to put up the criteria.
Give us a moment.
And I would ask that if, to the motion makers, that they identify which criteria they, specifically they did not feel the applicant met.
Okay, I feel quite strongly that the applicant has not met the criteria of, and minimum spatial separation of 500 feet from a similar use. And I want to,
This is for the variance, though.
That's not one of the variance
Oh.
criteria.
Those are the,
okay, let me,
Exception.
you know, I can't read that
I
because
know,
I'm
it's,
on an angle, so maybe you could just
Um,
summarize for me. I'm sorry, I can't see it at all.
well, if you recall, the variance is from the 500-foot, so the,
I
do you have a
thought-
shorthand of the
That's a
variance
special
criteria?
exception.
In your,
Because you did go over it.
Let's make sure I know what I'm,
500 feet.
in your packet, page
Right.
275 of the staff report is the variance review criteria.
so that's what,
But it's not the 500-foot. The variance was from the 500-foot
the
for the special exception criteria. But in order to grant a variance, you have separate criteria. This is the extraordinary circumstances, this is the hardship questions that staff went through in their presentation.
And again, page 275 of your packet is a portion of the staff report that lists the variance review criteria, followed by staff's analysis.
say that page again.
Page 275?
Okay, there I am.
So this is to permit the fast food restaurant, right?
Yeah, and this,
This is the variance from that 500-foot separation requirement.
and the variance criteria are that there be an exceptional or extraordinary conditions or circumstances that are inherent to the property, and the exceptional and extraordinary conditions or circumstances are not the result of actions of the applicant taken subsequent to the adoption of the ordinance. And I think both of those apply in this case.
Didn't you make the motion on that?
There's a motion
There's a motion
and a
to
second. We're
disapprove.
now talking
And
about it.
So we're not talking about it.
Does
We're not
Mr.
voting.
Mr. Worcester, do you concur
I
with those?
second the
Okay.
reasons,
Thank
the reasons for denial.
Is there any further discussion?
I'm sorry. I didn't really, what was the reason that?
That did not meet
To
the
deny.
first two criteria of the variance findings, that there be exceptional or extraordinary conditions or circumstances that are inherent to the property in question, and that the exceptional or extraordinary conditions or circumstances are not the result of actions of the applicant taken subsequent to the adoption of the ordinance. Any action taken by the applicant pursuant to lawfully adopted regulations preceding the applicant pursuant to lawfully adopted regulations preceding the adoption of the ordinance from this chapter is derived will not be considered self-created.
And I would add E to that, too. I have to read through these again, too.
Okay,
apologies.
let me ask for a point of clarification if I could. Those approval criteria were adopted in 2003 or 2004, so, and I think, I just want a clarification. Earlier, you indicated that you do look at the entire history. Is it now your position that you don't?
The clarification was requested from me of the board was of the special exception criteria, not of the variance criteria.
Okay.
And I believe that Ms. Craig has indicated that she also finds that finding number E, or finding 3E, the condition or situation of the specific piece of property or the intended use of the property for which the variance is sought is not of a general or recurrent nature, so as to make it more reasonable and practical to amend the ordinance. Am I correct in that?
Right.
Okay. So she's identified 3 criteria.
Okay.
Is there any further discussion?
Could we repeat the motion one more time, please?
The motion is to disapprove, the motion on the floor is to disapprove the variance.
So a yes vote disapproves.
A yes vote disapproves, a no vote approves.
And a yes vote would be in favor
Yes,
Of the app,
No.
of the
oh,
applicant?
no, the
No,
yes
no.
vote
no, the
is
yes
against the
vote
app.
will disapprove the application for
For a
variance.
variance.
Variance. The no vote would be
In favor.
in
yes.
favor. Okay.
Is there any further questions or comments by the zoning board? Roll call.
Bob and Serby,
Yes.
Barbara Craig,
Yes?
Russ Wynn,
No.
Chairman Carlender,
Yes.
Richard Donnelly,
Yes.
Roger Brunswick,
No.
James Worcester.
Yes.
We now move to the third question, the special exception. And do I hear a motion to approve or disapprove the applicant's request for a special exception?
I will make a motion to approve the request for a special exception. The applicant's request for a special exception.
Is there a second to the motion?
I second the motion.
Discussion.
I'm a bit confused, I guess, about that, but it seems to me that the council has made a very clear ordinance here. You know, I've read hundreds and hundreds and hundreds of statutes. That's what part of my research was for most of my life. And I know something about words in statutes that are aspirational. Go thou, make the air clean. But this statute seems to me to be very clear on its face. It has set out clear goals, and then it sets out very clear conditions, criteria to meet those goals. And one of those very clear criteria is that for the goal, in order to prevent a strip-like condition from being what is our corridor called 41, that we have this separation of 500 feet, and it doesn't say about 500 feet or somewhere around 500 feet. It says a minimum of 500 feet, and that's a pretty clear standard in a law, a minimum 500 feet. So I think we have to, we're supposed to, as a quasi-judicial board, make a reasoned decision based on law and fact, and the law here, to me at least, seems quite clear. And the facts don't match the law. They aren't 500 feet from a similar establishment. In fact, they're not 500 feet from several similar establishments. So I don't see how, as a board, making a reasoned decision based on the law, we can do this. Whether I agree with the law or not is immaterial, really. And what seems to me is the recourse for the applicant is if they think this is a unwise law, as I think you have stated you thought it was, is to go back to the council and ask them to amend the law. And if the council, it's a different council, the council in 215 is not the same council that's there now, thinks that this law is not appropriate any longer, they have the power to amend it. But I don't think we have the power to amend it. We have to apply it. So I will certainly vote against any kind of special variance that would not meet, I don't think, what the council has said the law should be.
Any further comments?
No, you make a strong argument, Mrs. Craig, but on the other hand, was that 500 feet? We don't know. I don't know. Was the 500 feet just an arbitrary number that they pulled from somewhere? Or is there reason that it wasn't 450 feet or 300 feet?
Well, that I think.
And also,
Okay.
in my mind, I'm wondering if the Wendy's would be torn down, burned down, go out of business, whatever might happen, the 500 feet would still be applicable for the, applicable for the buildings on the other side of 41, as I understand it, correct?
Well, I think the question that, and that certainly the
fast food
applicant
restaurants.
raised this, of whether this would apply in the case that something burned down or that the hurricane came, is not a question that we have in front of us at the moment. That's not the facts of this situation. The facts of this situation is this particular piece of property that was once a fast food, and then it was a bank, and then after both of those things happened and ended, the council passed a law in 2015 with a very clear purpose and some very clearly stated in the law criteria that we are supposed to apply in determining whether people can have a permission to build on this property with a special variance, or with a special exception or a variance or anything else. And I don't think, I mean, the council, if it has the policy-making power, we have the responsibility for applying law and fact. And I can't see how I could vote to allow this and respect the law. The law is there, and I think the council is the body that if it chooses to change that law, personally, I don't think the council can do that in a quasi-judicial hearing either. I think they have to change the law. But they have the power to change that law. There's a process they have to follow, but they do have that power, and we don't. And I just wish to be consistent when I go to another case. If the law says this, that's what you follow. And I don't see how I could be consistent with that if I were to vote to allow this.
I'd like to add something to that. I'm going to say probably about 7, 8 years ago, we had a case like this with the special exception. And it was stated to us then that it would have to go back to city council for them to amend it. So unless something has changed in the last 7, 8 years, which it hasn't, we have no alternative. We have to kick this back to city council and let them make a decision, let them make the amendment. We don't have the right to do that unless it's been changed within the last 7 to 8 years, which I don't think it has. So we have no other alternative but to kick it back to the city council.
And the only way we can kick it back in this case is to vote and give our reasons for why we vote to disapprove. But I wanted to just speak to the 500 feet. Laws often have requirements in them, and it didn't say 499 or 501, and so there's always a certain amount of arbitrariness in a figure of separation. And I think Mike made very clear that it doesn't matter how you measure this. Property line, they have 0. Building to building, or edge of building, center to building, they're still way under what the law claims. Now, if this were 499, maybe we'd have to scratch our heads or something. But even there, I think it says 500, and it's not our role to question why they didn't use a different number. That's the policymakers' power to make that decision. So that is the reasoning behind my recommendation, or my intent to vote against this variance.
Is there anything further from the zoning board? Call the question.
Restate what the vote will be on the question.
So,
So lost.
there is a motion to approve the special exception requested by the applicant. A vote, yes, approves the special exception. A vote, no, disapproves it. Is that clear to everybody?
Yes.
So it has to get kicked back to city council. With a no
We
vote.
With a
recommend
no
that the
vote,
city
right.
council gets a no vote.
Okay.
What they
Correct.
do with it is their issue.
Right. Roll call, please.
Bobbin Serpy,
No.
Barbara Craig,
No?
Russ Wynn,
No.
Chairman Carlender,
No.
Richard Donnelly,
No.
Roger Brunswick,
Yes.
James Orster.
No.
Council Rooney, is there anything further that we have to do?
No, I
to
don't believe that
conclude?
another vote is required.
No other
At this
vote?
point, the recommendation would be for denial to the city council.
Correct. Is there anything further from the applicant?
No, sir.
Thank you. So this matter is concluded. Our next meeting is scheduled for December the 18th. Prior to that time, we do have a meeting of the city council that we've all agreed that we're going to try to attend on December the 5th for the purpose of taking up our proposal to
Right.
change Article 4 as it applies to planned developments. Is there anything further to come before the zoning board? Hearing none, the meeting is adjourned.